it can't be a second bite at the cherry. You can't use 34-4 to make it like a review court and re-argue that case. Now, where the point is, now let's visualize what could be the ground to set aside the award. It could only be under 34-2 or 34-2A. Because patent illegality is a huge spectrum. It can be from a small thing to a large thing. We don't know.
But when subsection 4 discusses a particular position,
I know that. I'm not saying that.
Nazir Ahmad principle, when a law requires to be.
Yes, Taylor versus Taylor thing done in a, yes, that was right. Taylor, Singaram Singh, all the line of cases are there. You can't. I'm not saying that the court usurps the power of 4. I'm not saying that. The very purpose is given is, if this, now I'll tell you what happens. Suppose the ground for set-aside evidence is, suppose some documents have not been considered. In one issue, certain critical documents have not been considered. The other side says the issue has to be set aside because this critical document has not been considered. That has a material bearing. Now the 34 court can't go into appreciating evidence, summoning the document on. They'll say, all right, this document has not been considered. We'll send it back to the tribunal. Let them consider these documents and then decide the issue. That's what is 34 is contemplated. I'm on an illegality like a legal illegality, which doesn't require re-examination of evidence. I'm only saying, as my Lord Chief Justice is right, we can't say because 34-4 is there, the court can do the same thing which the tribunal can do. That is not my argument. That will be a wrong interpretation. I'm only saying there are various indications in 34 to say setting aside the award is the last resort. Wherever you can save it, try to save it. The only limitations are don't reappreciate it, don't do a review on merits. So my last submission, and I'll conclude with this, my submission is this. Partial set aside must be there. If the award is severable, my submission is, if the award is severable, because typically what will happen is multiple issues are there. It is not that all issues are patently illegal. Invariably, it will happen that one or two issues become bad. Like we all seen first appeals. When you go for a first appeal, the first court sees what are the issues framed, what are the answers on the issues, and then we argue that matter. All of us have argued first appeals and second appeals. That's what we do. But my submission is, apart from the classification of severable and non-severable, I'm now going into 2 points because curable and non-curable. Well, ultimately, we have to make sure that arbitration becomes a vibrant alternative force. Today, what's happening is with this kind of interpretation of saying that you can't touch it at all and all that, then people are going to be very hesitant to go to arbitration. And if I'm going to have an arbitration clause and after 7 years, I'm going to be sent back, no, now you set aside, start on your own, then what is the purpose? The whole purpose is completely lost. Then it doesn't become an alternative dispute mechanism. It becomes a dispute mechanism which will be forced upon me because I have no other power but to listen to the contracting party. So I have to get the contract, I have to sign that arbitration clause. Now, the second submission I'm making is, yes, once you accept that there is a power to partially set aside the award, then my humble submission is leave it to the court because the limits are given here. Don't review on merits, don't reappreciate evidence, don't correct errors of law, application of law. Those limits are there. I'm saying, please examine this point, which I'll conclude with this. In my example of 7 issues, suppose the 2 issues are not severable. That infection affects the whole award. It's not severable. Then what does the court do? My humble submission is the court must then examine what is this patent illegality in these 2 issues which is infecting the whole award. If that illegality, patent illegality, doesn't require reappreciation of evidence, doesn't require correction of application of law, doesn't require a review on the merits, those 3 constraints, then the court can always say, look, instead of setting aside the whole award, I will remedy the illegality to the extent the illegality can be corrected, like a course correction. The award is off track, bring it on track. and save it. And it has been done more than once. Lordship will kindly see through those judgments. I'll give the example. Lordship will just note. Lordship will note the citation. Indian Oil Corporation versus Ganesh Petroleum. 2022 4 SCC 463. 2022 Volume 4 SCC 464. 463. Here what happened was the award altered the terms of the lease. They made it 20 years into 9 years or 10 years. They changed the rate of rent. Now we altered the whole thing completely. What did the court do? They said, no, if it's a 20-year lease, it should go back to 20 years and restore the rent. So what they did was the award was modified to make it conform to the lease agreement, and it was then allowed to stand. That has happened. Then take State of Chhattisgarh versus Sal Udyog, 2022 2 SCC 275. The award did not consider an applicable government circular. It was modified to bring it in terms of the circular. Two more examples I'll give. SsangYong, the Honorable Supreme Court says majority's award is wrong. I am taking the minority award as the correct award, which I think is a very extreme example of modification. Suppose there's a dissenting award. Under 34, can the court say that there are two awards in front of me? I will sustain the minority award. Or do you set it aside fully and send it back? Maybe one can take the view that if the majority is so patently wrong and the minority is a well-reasoned award, that's what been done by the Supreme Court. And lastly, Hakim. As far as Hakim is concerned, my humble request is.
Third one, you've not given us the citation.
Sorry,
SsangYong.
SsangYong citation. I'll give it in a minute. SsangYong and McDermott, I'll give both the citations.
Certain citation.
SsangYong is 2019 15 SCC 131, and Hakim is of course in the referral order 2021 9 SCC page 1.
2021.
9 SCC page 1. This is part of the
Hakim.
order. That's Hakim.
Okay.
There is National Highways versus Hakim. And McDermott, which is Justice Sinha's judgment, 2006 11 SCC 181. 2006 11 SCC 181.
I think I'm party to Hakim.
Pardon me?
I was part of the bench in Hakim.
Part of the in Hakim, yes. And I think Mr. Justice Sinha was the counsel in Hakim.
Council.
No, I was not there.
Yeah, he's counsel in? Sorry. Yes,
What is the page number of SsangYong?
131.
13.
Now, my lord, I have also referred to the case law compilation which we have given. Please see Vedanta. Vedanta, if the court master can put it up. Where is Vedanta? Yeah, wait. Vedanta 2019 11 SCC, page 463.
2019.
11 SCC 46.
Page 416 of our common compilation.
465. It is page 416 of the common compilation. You know, all the cases are in the common compilation. Now, please come to para 11 of the judgment. If they can put it up. (2019) 11 SCC 465.
In 19, the initial says yes, it's
Please see para 11. That's important. May I read para 11? May I read para 11? Yes. Yes, please see para 11 in the screen. Lordship will see para 11 in the screen.
I got the.
Courts may reduce the interest rate awarded by the tribunal where such interest does not reflect the prevailing economic conditions. That's one part. Where it is not found reasonable or promotes the interests of justice.
Now, tell us one, the 2-3 things. Can the court also increase the rate of interest?
Pardon me?
Can the court also increase?
Yes,
the rate
my
of
answer is yes, because suppose the arbitral
Just one.
tribunal.
Just one. Now, if one goes by that, that means this is a complete case of merit review.
Sure.
This is a complete case of merit review
No, I'll tell you, Lordship, why.
because
Sorry.
it is rate of interest has an element of always has an element of discretion. Rate of interest always has an element of discretion until unless by statute that
Or by contract.
or contract is taken away.
Yes.
And as far as pendant right is concerned, it's always under 34 also a matter of discretion of the court. Now, if one looks at the rate of interest provisions also, it says that where the arbitrator is not awarded interest, post-award rate of interest, then the statute itself prescribes the rate of interest. Can the court then read down the rate of interest? Suppose the award does not prescribe the rate of,
Can I give an example, Lordship?
but because then it provides that. So in this case, will you not read down that the discretion of the court is taken away because by default, if the arbitrator has not awarded post-award rate of interest, then there is specified rate of interest.
But on the interest issue, there is a problem here because the contract is 18%. Very often, if the other side is a public sector, then the court says.
No, the reason why I say the increase in rate of interest because most of the government contracts, there's a specific stipulation, no interest will be awarded.
No. Let's come to a contract where interest is awarded.
So the reason why I asked you that was, and there are judges of this court, the arbitrator is bound by those conditions.
Correct. In fact, in many of the government contracts, other problem is, as a tax lawyer, they say that the price is all inclusive. Even if there's a hike in the taxes, you have to bear the cost. It also has been held to be valid. I'm not on that. I'll tell you a practical problem which we have faced in Madras. Many of these finance companies are there. Now they give loans for sale for car and motorcycle. And now what they say, the interest is 18% per annum. Because they have to borrow at 12% unless they have the arbitrage, they can't sustain. There is a clause that if you default for more than 3 months, the interest becomes 24% or becomes 36%. Now, in the light of what your Lordship said, in many of these things, there are arbitrations where they appoint lawyers to the small arbitrations. The default is 2,80,000 like that. Very often they seize the vehicle, only the balance they have to recover. Now, my submission is if the contract says that a defaulter has to pay instead of 18, 24%, and if the arbitrator awards only 18, ignores the contractual rate, my humble submission is the court can change it in the interest of justice to 24. Why not? That's my question. And in fact, our High Court, or the Honorable Supreme Court has held, you can't have a separate yardstick for government companies. You can't have some kind of sympathy. If they have the clause, then they have to also have the thing. But to answer your Lordship question, can you increase it? You can increase it to make it in terms of the contract. Only one thing is there, Maran. On interest, please come to section 28 of the Arbitration Act. That's very important, which we lose sight of. Section 74 of it. 28 is again borrowed from the UNCITRAL. They modified it in India. 28 is very important. Again, it is peculiar for domestic arbitration. May I read 28 1A, my lord? 28 1 small a. The Lordship's got it, my lord? Yes. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. Now, this is a mandate given by the legislature. Once the arbitration is being held in India, if the place is in India, then the substantive law of India applies. Now, Lordship gave the example of interest. What does the Contract Act say? The penal interest, the Lordship takes section 74 of the Contract Act. They say that a clause, suppose I say it's 18%, but if default it is 48%, suppose I make it highly issued. Then the Contract Act says such a law is in terror. It's in the nature of a penalty. It is not permissible. So the arbitrator can always say he has to decide in accordance with the substantive law of India. Section 23 of the Contract Act. If a clause is against the public policy, the agreement is void to that extent. So I am saying that the patent illegality can also be seen from 21A. If the arbitrator has ignored the substantive law of India, then the remedy is either to set aside the award or to make sure that it fall in line with the substantive law of India. Why set it aside? If you can just, like my Lord the Chief Justice gave the example of a formula. The arbitrator has not completely applied the formula, he has missed one particular part of the equation. You can just change it to that extent. Why send it back for that purpose? That's my submission. So, my Lord, I'll just conclude by saying that one more thing as far as Hakim is concerned. My Lord Justice Vishwanathan asked the question, what about reversal? Set aside and reversal. My submission is, suppose the particular issue in the arbitral award has taken view X and the correct substantive law is view Y, then it need not be set aside. The arbitral tribunal, the section 34 court can simply say, look, I'm ignoring X, I'm going to put it as Y, which is exactly what your lordship did in Sal's thing. You said, you ignored the circular, I'm applying the circular, I'm doing it. To that extent, it is a reversal of what the arbitral award did.
Is that not varying? Is varying different from modification?
But we thought about it, we discussed it. But basically, we are on a fundamental basis. When a lordship partially sets aside the award, are you not modifying the award? So are we not on a question of semantics? What is modifying? What is varying? In the long run, we will have to come to a situation where we adopt some of the clauses like Singapore, UK, which Learned Solicitor has given, where there is express power to modify the award, vary the award. Please see section 48 of the Singapore law, which it says, he has quoted. It says the court shall not modify the award under any circumstance, except as provided in the Act. That's 48 of the Singapore Act. 49 then says a domestic award can be varied, modified. The Lordship sees Learned Solicitor's notes. You have quoted section 48.
48 is
That is a bar.
in principle similar to section 5 of our act.
No. 48 says, no, see, 47 says, Lordship will kindly note section 47. In Singapore, the court does not have jurisdiction to confirm, vary, set aside, remit an award on arbitration and agreement, except where so provided under the Act. And provided under 49,
Of our act.
and under 49, they say the court can, in that on appeal, the court can confirm the award, vary the award, remit the award in whole or in part, set aside the award whole or in part. Singapore 49(8), 49 subsection 8. Therefore, my Lord, my humble submission is, ultimately, as I gave that note, I would request the court to add the words. I gave the chart on the last occasion, where repeatedly the court have added a few words here and there to sustain the award. And I also mentioned the court, Justice Vishwanathan noted it, on Seaford Court Estates with Lord Denning. Can I take that passage? But I'll just give it in the course of my reply. Well, what Lord Denning says is, he says, acts of parliament are not made with divine prescience. English language is an imperfect instrument. So the act of legislature cannot cover every possible eventuality. Will the court master have the Queen's bench? Otherwise, Lordship will note the citation. Lordship will just bear with me. I'll just give it. Yes, Seaford Court Estates Limited versus Asher, 1949. 2 Olia, 1949, 2 Olia reports 155. Last time I gave it to the court master. 155. And Lordship will then come to the concurring judgment of Lord Denning at page May I just read that passage, Manoj?
Yes,
Can I just read it and I'll conclude?
yes.
It's at page, starts at 155, Lord Denning's concurring views at page 164. Very nice passage. I'll read, Manoj. Whenever a statute comes up for consideration, it must be remembered that it is not within human powers to foresee the manifold set of facts which may arise, and even if it were, it is not possible to provide for them in terms free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much the poorer if it were. This is where the draftsmen of Acts of Parliament have been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must see the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some ambiguity. It will certainly save the judges trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of, now this is the problem, in the absence of it, when a defect appears, a judge simply cannot fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, not only from the language, but also from a consideration of the social conditions which gave rise to it, the mischief it was supposed to remedy, and then supplement the written word so as to give force and life to the intention of the legislature. To put it in homely metaphor, a judge should ask himself the question, how? If the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done, that legislature would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. So my humble submission is, by adding 3 words as I suggested, lordships are not altering the fabric, you are ironing out the creases. I'm grateful.
By Lord's permission, may I follow Mr. Tata? But I am appearing in IA 9364 and 9401 of 25. Not, I've also prepared an additional compilation of just the judgments that I wish to show my lords, which I will take my lords. Earlier I had filed a 3-volume, but I think this is much more handy. This ahead. The aim of arbitration, as my lords have held, in the interplay with Stamp Act judgment, is to provide speedy, efficient, and binding resolution of disputes. And there's a delightful passage from Redfern and Hunter, which my lords have also quoted there, which starts with the advantage of arbitration is expedition where the law is slow. The Act itself, apart from the objects and reasons, has a lot of internal evidence to show that speed and finality forms the fulcrum of the Act. Very briefly, Section 29A, the time limit of 12 and 6 months. 29B, fast track procedures. 34(6), disposal of 34 within 1 year. All these show that the intent of Parliament is speed and, of course, finality. Now, the question before your lordships is that if under 34, the court only has the power of annulment of an award, either wholly or partially, it would mean that a successful party who has succeeded, say, 90% of the matter before the tribunal, has failed on one question of law, has then succeeded in the 34 in getting the finding of a court that this is a patent illegality, would then be relegated to restarting the entire process all over again from day one, which is an immeasurable cost, hardship, and completely contrary to the object and purpose of the Act. It would undermine the very idea of arbitration itself. Now, today, your lordships are faced with this situation. Certain foreign jurisdictions, as the learned solicitor has shown, has got express provisions to vary. Our Act does not have an express provision to vary. And though the Dr. T.K. Vishwanathan committee has recommended that, that recommendation has still not been incorporated. So we are left with two major arguments against giving any power to modify to a 34 court. Let me state them straight away. One is that there is no express language in section 34 itself. And coupled with section 5, one is restricted only to the express language of 34. And the second is an alarmist one, that if a court allows modification, the floodgates will open and you will convert 34 into an appeal, which it is not. Let me address both of them. First, the source of the power. I intend to argue in two compartments. My first compartment will be that, in fact, 34 itself contains the power. And my second compartment will be that in any event, the inherent power, particularly of high courts that are constitutional courts of record under Article 215, is never taken away, even when they sit under a special statute like the Arbitration Act. That will be a second compartment. I'll deal with that separately. And then I propose very briefly to suggest certain guardrails to meet the floodgates argument, because I don't think anyone who is pro-arbitration wants a complete, unfettered, unguided power of modification. And my submission there is going to be that that power can be hinged exactly within the discipline of 34. So, for example, patent illegality is a ground on which an award can be set aside. To come to that conclusion, a 34 court would necessarily have to determine what the correct position of law is to determine that there is a patent illegality. The only suggestion is in those cases, without reappreciating evidence, without allowing a reconsideration of merits, permit the incorporation of that correct position of law into the award with only consequential modifications. Therefore, that is completely within the discipline of 34, not outside. Now, may I go first to 34 itself? 34(1) is the source of the power. 34(1) tells us that recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and 3. So to have recourse to a court, you can have recourse only via an application for setting aside. You can't simpliciter file an application of modification or appeal. You have to first fit within the discipline of 34 to even have recourse to the court. But what you then have is recourse to the 34 court. Now, it is very well settled that even when the express words do not indicate a wider power, if the wider power of annulment is conferred on the 34 court, that would include all lesser powers. And a lesser power would include the power to modify under certain restricted circumstances. This, as your lordships have held in the Sakiri Vasu case, is the doctrine of implied power. Would my lords just turn for one moment to the very first judgment in this compilation? That is Sakiri Vasu, 2008, 2 SCC, page 409. At para 18 onwards. In para 18,
Para 18.
para 15. Para 15 is section 156(3) provides a check on the police performing its duties under chapter 12 CRPC. In cases where the magistrate finds that the police has not done its duty of investigating the case at all, or has not done it satisfactorily, he can issue a direction to the police to do the investigation properly and can monitor the same. Power in the magistrate to award further investigation under section 156(3) is an independent power and does not affect the power of the investigating officer to further investigate the case, even after submission of his report under 173(8). Hence, the magistrate can order reopening of the investigation, even after police submits the final report. 1017. In our opinion, 156(3) is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation. And it includes the power to order registration of an FIR and of ordering a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. 156.3, though briefly worded, in our opinion, is very wide, and it will include all such incidental powers as are necessary for ensuring a proper investigation. Then in para 18, it is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers which would ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, there is impliedly included in the grant, even without special mention, every power and every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly also grants the power of doing all such acts or employs such means as are essentially necessary for its execution. I would respectfully submit that there would be an implied power in the 34 court to do everything necessary to save the award, even in cases where it finds that the whole award or part of it is vitiated by a patent illegality. And then para 20, in ascertaining a necessary implication, the court simply determines the legislative will and makes it effective. What is necessarily implied is as much part of the statute as if it was specifically written therein. So no need to write in any words. This doctrine allows your lordships to find that power in 34 itself, provided your lordships are satisfied that the idea of 34 is a recourse to a court, and the object and purpose of the act is to protect and further awards and to make the entire process speedy and final. In fact, your lordships may also invoke another doctrine, which is the doctrine of molding the relief. Your lordships will see the second judgment. Please turn to page 10 in ARCE Polymers 2022 2 SCC 221. And at paras 22 and 23, your lordships have enunciated the doctrine of molding of powers. 22 first, at running page 24 of the compilation. In consideration of the facts of the present case, another important aspect to be duly noted is the power of the court's judicial authorities to mold relief, while holding that the general approach is that the claimant who succeeds in establishing the unlawfulness of administrative action is entitled to grant of a remedial order. The general proposition does not undermine the discretion which the courts or judicial authorities have in assessing, quote, what is fair and just to do in the particular case, to withhold the remedy altogether or to mold the remedy by grant of a declaration rather than a more coercive quashing, prohibiting or mandatory order injunction which may have been sought. So your lordship,
Well, this is in respect of something else.
something completely different, but the doctrine of molding the relief would equally apply to 34. Is the 34 court left powerless to actually remedy the situation and subserve the object of the Arbitration Act, rather than to adopt the harsher remedy of setting aside and then leave parties to their remedy, leave them anchorless for the next several years to restart and relitigate the entire matter in arbitration? I would submit no, a court always has this power. Now, merely because there is no express power given in the statute, that does not imply that there is a prohibition. I'll come to section 5 later, but first, the lack of an express power does not imply a prohibition. Your lordships in Centro Trade, the third judgment at page 27, and Hindustan Copper have held exactly this. This is in 2017, 2 SCC 228 at para 23. At para 22 first, your lordships at page 42 have referenced the previous judgment of this honorable court in ITI, where the question before this court was whether the provisions of the CPC were applicable to the Arbitration Act or not. In response, this court observed that since there was no express provision excluding the provisions of the code in the Arbitration Act, it cannot be held by inference that the provisions of the code were inapplicable. Now, I must tell my lords that in fact a subsequent bench of 2 judges, I put it in the compilation, has doubted the correctness of this judgment and has referred it to a larger bench, and that reference is still pending. But today the thought that the CPC could also apply has already been held by your lordships in ITI and not departed from in Centrotrade. Then para 23. In any event, we are afraid the passage referred to by counsel from First Day Lawson has been misunderstood and is even otherwise inapposite, since we are not concerned with a statutory appeal, but a non-statutory process agreed upon by parties that has nothing to do with court procedures. We are also unable to fully subscribe to the broad observation that acts mentioned in a statute are permissible, but acts not mentioned therein are impermissible. So the mere non-reference or silence at highest of an express reference of the power to vary or modify does not mean that that power cannot be read into section 34, because there is no prohibition. And we see, for example, the example of Singapore. My learned friend, the solicitor, cited section 47 of the Singapore Act in his written submissions at page 23, where there is an express prohibition to vary the award except as provided under this act. There is no such provision, and section 5 is not akin to such a provision. So I would submit that both by the doctrine of implied powers as well as by the doctrine of molding the relief, there is sufficient power in a 34 court to modify the award, albeit in a disciplined and restricted way. Let us take the question of severability. My learned friends fairly accepted that the general doctrine of severability is now well accepted under 34. And I've given just 2 judgments in this compilation. I won't read them. JG Engineers at item 4. That is at page 52. Your Lordship's Court, where at paras 24 and 25, certain claims were severed from other claims and they were upheld, and the other claims were set aside in the award. And the case of Jivani of the Bombay High Court, which is the last judgment, page 804, where a full bench again upheld this doctrine of severability in section 34. Now, what is important, in fact, my Lord the Chief Justice has been pointing this out, is that the express language of 34, 2A4, the proviso, which contemplates severability, very clearly is restricted only to severability of such matters that fall within the scope of reference and to sever those that fall outside the scope of reference. If that was the limited doctrine of severability, none of these judgments could have been delivered, because these judgments are on the broader doctrine of severability. My Lord, just see 34, 2A4 for a moment. Thirty-four 2 says an arbitral award may be set aside by the court only if A, the party making the application establishes on the basis of the record of the arbitral tribunal that, small Roman 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decision on matters beyond the scope of the submission to arbitration. So the express recognition of severability is limited to what falls within the scope and what is outside. Yet, your lordships and other courts have repeatedly applied the general doctrine of severability to save awards. And my learned friends accepted that that is part of section 34. So here is one classic example where the express language of 34 does not extend to such a power, but courts have always read that power in. Why have they read that power in? It is because they are cognizant that 34 is a recourse provision, and that the aim and object of the act is finality and speed of dispute resolution. If an entire award had to be set aside merely because one portion of it was vitiated by, say, patent illegality, and the others were clearly separable, then it would not subserve the aims and objects of the Act and would not then be a correct exercise of jurisdiction under Section 34. That is why the general doctrine has well been accepted. Now, the doctrine of severability generally is nothing but modification of an award. An award starts on a particular footing. When it comes to the 34 court, it starts its life as a decree, as it were, on a totally different footing because one has severed parts of it. That is a clear modification and a power to modify. Indeed, your lordships sitting in a 3-judge bench in Western Gecko, 2014 9 SCC, page 263. 2014, 9 Supreme Court cases, page 263. Item 5 of this compilation.
Yes.
At page 72, paragraph 40, page 89, have referred to the power of modification, basing it on the doctrine of severability. My Lord, we'll just see para 40 for a moment, page 89. It is neither necessary nor proper for us to attempt an exhaustive enumeration of what would constitute the fundamental policy of Indian law, nor is it possible to place the expression in the straitjacket of a definition. What is important in the context of the case at hand is that if on facts proved before them, the arbitrators fail to draw an inference which ought to have been drawn, or if they have drawn an inference which is on the face of it untenable, resulting in miscarriage of justice, the adjudication, even when made by an arbitral tribunal that enjoys considerable latitude and play at the joints in making awards, will be open to challenge and may be cast away or modified, depending upon whether the offending part is or is not severable from the rest. So 3 judges have accepted that severability is a facet of modification, and that if the conditions for severability exist, there is a power to modify. Now, my learned friend, Mr. Datar, cited several judgments, Your Lordship, and obviously I won't repeat them, on even the power to add words. I believe with the submissions I've made just now, there's no necessity of adding words. It's part of the recourse and the setting aside power that you can sever and or modify. Because the first step in modification is severing. If you can't sever the vitiating part, then you can't modify. Modification only means that if I've already decided that this is the correct position in law, and completely erroneous and patently erroneous position has been followed, then surely one can replace that portion of the award with the correct position in law. Take a classic case of limitation. Let us take an award where a party has completely succeeded on the contract or the transaction. Evidence has been left.
The biggest mistake when starting a business is investing all your money in a complex website. GoDaddy allows you to create a beautiful catalog for your products and engage directly with your customers. Simplify your online presence with GoDaddy Show and Bio.
Just with an application of the correct position of law. Therefore, I would submit in such cases, it is indeed the duty of the 34 court and well within its powers to make that modification. And I'm not today getting into a distinction between rate of interest. Is it rate of interest only that you can modify, or is it other things? My formulation is, please read in a power of modification, restricted to the guardrails and discipline of 34. That is to say, something that must be on the basis of the factual record and determination of the tribunal as it exists. No reappreciation, no entering into merits. But if you find that patently there is an illegality, which you have corrected in order to set aside the award, then why set aside the entire award? If the entire process of arbitration and award can be saved by merely incorporating your correct determination of law into the award. Your lordships have done that repeatedly, but under Article 142. Now, every matter cannot come up to your lordships under 142. That will be a flood of matters there. Therefore, I would respectfully submit, it does make sense to read this power into 34 as an implied power and within the larger power of annulment or setting aside, because 34, as 34.1 tells us, is a recourse provision. It's not just an annulment provision.
Secondly, the tenor of 34,
Yes,
though the marginal note says setting aside,
yes,
read entirely with special focus on 34.4,
yes.
shows that the idea is to uphold the award.
I'm obliged.
Final power is really to uphold the award,
I'm obliged.
though couched as setting aside.
And that is completely consistent with the object and aims of the Act. And my Lord is right to refer to 34.4. If 34 only had a power of annulment, then there's no question of 34.4.
Otherwise, your implied power argument won't sit in, because the final power is to set aside. By modifying, the final power is not effectuated. In sum and substance, the power is really to make an endeavor to uphold it within the parameters of law.
I'm obliged.
In exercise of that final power, if there is a power to effectuate that final power, should the court be deprived of it?
Lordship. I'm grateful, my Lord. May I adopt that as my submission, my Lord? I'm grateful to the court for putting it so it's illegal. Now, the judgment in Seaford, which my learned friend read, I must just, for the record, point out also that in Bangalore water supply, 7 judges of our court have expressly accepted that principle. And that's the judgment at item 6 of the compilation, page 90. And the relevant portion is at para 40. I'm sorry, they're at para 19, at page 109. Where the Seaford passage, para 19, I'm so sorry. 19, at page 109. And we always tend to cite the latter portion of this para, which is a court should iron out the creases but must not alter the material. But the earlier portion also is very interesting, and may I just show that to my lords at the bottom of page 109. My learned friends read a bit of it just now.
Yes.
The quotation is of Lord Denning: the English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. He must set to work, that is the court, in the constructive task of finding the intention of Parliament. And he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of the legislature. A judge should ask himself the question, how if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. Now, please apply this squarely to our position. 34 is a recourse provision, and as my Lord Justice Vishwanathan put it to me, in fact, the substratum of 34 is to try and save an award rather than to nullify it or annul it. That is the material of section 34. All that it requires for your lordships to do is not even add words in, but interpret 34 as including the ironing out of this crease, that if you can, within the discipline of 34, modify the award by incorporating the correct position of law and obviously then consequential changes to the award, just by that, without reappreciation, would that not subserve the mischief which was intended to be remedied by the Arbitration Act, which is protracted litigation, cost, etc., and in fact subserve arbitration and subserve the Arbitration Act? Because the argument on the other side, with utmost respect to all my learned friends, does not subserve arbitration. It defeats it. It defeats the whole aim of arbitration. to take such a rigid and inflexible approach. And I don't believe Section 34 is not admitting of some play in the joints which your lordships cannot interpret.
Taking a cue from what you read out, Mr. Kadrata.
Yes, ma'am.
This is an issue which has been vexing this court at least since saw pipes in 2003.
I understand.
The parliament had the occasion to amend this act twice,
Yeah.
2016, 19.
Yes.
We cannot presume that they were unaware of this problem,
No, of
which
course.
is vexing this
Of
court, vexing the very institution of arbitration. In spite of that, they have not made a change.
That is true.
This is something that Justice Nariman has touched upon in Hakim also.
That's it.
How do you get over that?
Yes. I would put it this way, that if your lordships are satisfied on an interpretation that the power exists in 34, then the fact that Parliament has not thought it fit to make an express provision would not alter that determination or interpretation of 34. It may be that the position would have been much clearer had they put in a separate subsection. But equally, they didn't put in a subsection on the Doctor
Does it
General.
not convey the intention of the parliament that there is no requirement for a change? They left it as it was despite being aware of the problems that
My lord is right.
session was facing.
That is certainly a factor that your lordships can take into account to interpret 34. But on the other hand, if the plain language of 34 admits of a wider construction and interpretation, the fact that Parliament chose not to put in a specific provision should not alter that interpretation. That's my submission. And therefore, my respectful submission is either the fact that this was before Parliament or even the fact that the 1940 Act contains Section 15. I understand the solicitor. My lords have seen Section 15. I won't go through it again. But section 15 is only the equivalent of existing sections under today's act. So 15A is the separability provision of beyond the scope of reference, and B is imperfect in form or obvious errors. C is accidental slips or omission. 33 covers that. So 15 is not different in that sense from the position even today. And therefore
If one goes by 15,
yes,
A is obviously included.
is included.
Even
Even
in perfect form, it is an obvious error that's also included.
yes,
An award contains a clerical mistake or error resulting from accident, slip or omission. This is obviously an implied power which every court has.
would always have. Would always have.
Because they suppose while writing the final part of the award, a figure mentioned omits 2 zeros
Absolutely.
or
That
1
always be
zero.
part. That was all.
That will be, you can't say that the
33A covers it.
33A.
And 33A itself gives you the right even to go back to the tribunal if you would so wish. So 15 is really covered. There's no absence of 15. In fact, the acts are in paramateria, and therefore the report.
And what was material at that time when we implemented the 1996 Act? Let's not forget. That was the occasion in 1990, liberalization has started.
Yes.
We were expecting foreign investment to take place. And normally arbitration is the method of dispute resolution resorted to in cross-border dispute.
Not. My lord.
That's a default mechanism. Court decisions are not default mechanism.
And finality. What the litigant wants is finality.
Whatever it is, but that's because every party invariably, when they want to invest or have a cooperation agreement, they insist on arbitration. Unlike courts being the default mechanism as far as internal disputes are concerned.
And unfortunately, many of them insist on a foreign-seated arbitration.
That's something separate. That's also changing.
That is changing, and the 2015 amendments, which ring-fence international commercial arbitration, has gone a long way in ensuring that. Now, even foreign parties are more than happy to have India-seated arbitrations. And because of your lordships and other high courts, pro-arbitration.
So that's not
right.
that's not the issue.
That's not the issue. I'm not.
So what happens was we adopted the unisexual model,
Yes.
which is basically framework also of the New York Convention,
Lordship.
more or less on that. We adopted that model and we just simply did it. But if one goes by that, normally we say we have to interpret the intent of the legislation. But while doing so, we have to be practical also, because legislation never meant that they will be impractical or something which is so obvious, which will be looked upon or can be overlooked by us.
My lord, if the intent is speed and finality, then fettering or making 34 rigid is contrary to that intent. So a purposive interpretation of 34 would only result if this limited discipline power modification is read into 34. Otherwise, it would be contrary to the intent.
There's another aspect. Yes, there have been earlier the amendments were always very infrequent, very, very rarely done. Now, but the good thing which has happened is amendments have been taking place, whether it's the IBC Companies Act or for that matter Arbitration Act, whenever they have found that there are problems. And if one goes by the latest amendment, which is a proposed amendment, we don't know whether it will be. There is a provision now dealing with modification.
Yes, now that's. But what happens in the interregnum is really.
We don't know.
We don't know what might happen.
We should not go into that case.
So I'm assuming that there's no express provision. My argument is based on that. But there's certainly an implied power of provision, and that can be read into the existing provision as well. And this would not be contrary to parliamentary intent. In fact, it would subserve the intention of the legislature.
And according to you, there is no provision also.
There's no prohibition, unlike Singapore, which has an express prohibition. Now, my lord, I am aided in this by the very fair submissions of the learned solicitor. My lords would kindly turn to his written submissions at page 137. Para 174. In fact, para 172 at page 136. 172 at page 136. This is under the part that is headed Possible Ways of Reading in Power Modification. These are the Solicitor General's submissions, the actual written submissions, not the compilation of the actual submission. Para 172. However, after referring to Hakim's judgment in 171, the learned solicitor submits, however, such literal and stringent interpretation of Section 34 of the 96 Act has posed many practical challenges. One recurring issue is regarding the calculation of interest, wherein the award suffers from no infirmity other than that of awarding an exorbitantly high or cut rate of interest. However, in absentia of provision regarding modification, the courts are left with limited remedy, i.e., either to set aside the award or remand the matter as per circumstances in subsection 4 of 34. Then he goes into the conflicting decisions. Page 174. After in 172 and 3, he sees the decisions of your lordships. In 174, he makes a submission. It is submitted that reading modification power into section 34 of the 96 Act is in furtherance of the object of the 96 Act. He's absolutely correct. It is settled principle that a statute must be construed to make it effective and workable. And then para 176 at page 138. Practically, the absence of a modification power leads to wasted judicial resources, as courts often have to set aside entire awards, even when a minor correction would suffice. This contradicts the pro-arbitration approach of minimal judicial interference and speedy dispute resolution. While it is accepted that courts should not rewrite awards or review merits, a narrowly tailored modification power limited to curable defects would align with the objectives of arbitration law while ensuring justice. But if God, he then says this again ought to be appropriately dealt with by the legislature. But in para 174, he says even under 34, there is a modification power. So on objects, the learned solicitor has very fairly stated, speed, finality is the object.
In the beginning also he said that there are problems.
There are problems. He was very fair in making that sort. Now, that's the first basis on which I would submit your lordships can read in a power. But there is a completely independent basis as well, which I've got to quickly go into. This is the basis of inherent powers of a court. A court hearing matters under the Arbitration Act, a special statute, would nevertheless retain the character, its own character as a civil court. The definition of civil court is in 2(1)(e). And that can sometimes be a district court, my Lord Justice Gawai gave the example, or it could be the High Court, depending on where you are. Because sometimes the High Court has original jurisdiction and therefore would be the district court for those areas. I'm going to deal with the two of them separately, if your lordships permit me. As far as High Courts are concerned, when they exercise the 34 power, they remain constitutional courts of record under Article 215 of the Constitution. No part of that power can be ceded or taken away, even by Section 5, which is a statute, even assuming Section 5 can be extended to the powers of the 34 court, that can't be taken away. Your lordships have held so in the context of Articles 226, 227, and other articles, that the High Court's constitutional powers conferred on it by 215, and in fact pre-existing as courts of record, cannot be taken away by Section 5. Just as your lordships, Article 142 powers cannot be taken away by Section 5. Because these are constitutional powers. Now, two judgments very briefly on this aspect of what is a court of record and what is its scope, ambit of its power. The first is in the celebrated Mirajkar case, Naresh Mirajkar. And that my lord will find in the additional compilation at item 9. At page 463. This is 1966 3 SCR, page 744. And if my lords are pleased to go to page running page 486 of the compilation, para 59. Para 59, the running page 486 of the compilation. There is yet another aspect of this matter to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish contempt of itself. One distinguishing characteristic of such superior courts is that they are running page 486 of the law. There is yet another aspect to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish for contempt of itself. Then the para goes on to say such superior courts have the power to determine their own jurisdiction. And then about 2/3 of the way through the para, 10 lines from the bottom of the para, in support of this view, this court cited a passage from Halsbury's Laws of England, where it is observed that, quote, prima facie, no matter is deemed to be beyond the jurisdiction of a superior court unless it is expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless it is expressly shown on the face of the proceedings that the particular matter is within the cognizance of the particular court. And then we go on to para 61 at page, it starts at the bottom of page 486, but the portion at page 487, the last 4 or 5 lines of para 61. Therefore, in our opinion, having regard to the fact that the impugned order has been passed by a superior court of record, in the exercise of its inherent powers, the question about existence of the said jurisdiction as well as validity or propriety of the order cannot be raised.
This will be a slightly truncated argument. That will be given some specific powers to the constitutional court.
Constitutional court. So that would
that may not be.
Therefore, I am making that slight distinction.
That power would be available only to the High Court and not to the.
That is true. That is true. Therefore, I say I'll deal with both separate. I'm going to deal with district courts.
This will be little more.
May I just place the point, my lord? There are several other paras which.
So if an arbitration arises in Thana,
It may have problem.
No, there is a remedy.
You'll have to section 30.
Sheru, hi.
May I help you?
ओए, तुम्हारा लायन किंग यहाँ है नेहा।
Oops. कॉपी कैट दिख रहे हो? चीप शोरूम से सेम ट्रेंड हंट करोगे तो यही होगा ना?
मेरी बिल्ली मुझे ही मियाँ।
Babe, just shop from Forward. Get 1 lakh plus trends for everyday vibes under 599.
पहले क्यों नहीं शेयर किया?
हाँ.
हर्ट से हटके Forward by Myntra.
In para 14, your lordship said the High Court is a court of record as envisaged in Article 215 of the Constitution must have inherent powers to correct the records. A court of record envelops all such powers whose acts and proceedings are to be enrolled in a perpetual memory and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. Then page over, on the top of the page, they refer to the Mirajkar judgment, then the passage from Halsbury, and then in parenthesis after the passage from Halsbury, the Supreme Court notes that though the references to English courts, the principle would squarely apply to superior courts in India also. And then 16, referring to the said passage and relying on the decision of this court in Naresh Mirajkar, a 2-judge bench of this court in M.V. Elizabeth has observed, quote, the high courts in India are superior courts of record. They have original and appellate jurisdiction. They have inherent and plenary powers, unless expressly or impliedly barred and subject to the appellate or discretionary jurisdiction of the Supreme Court. The high courts have unlimited jurisdiction. So if a high court is hearing a section 34, one cannot say it doesn't have the power to correct the record, because ultimately the award will be treated as a decree of the high court for execution purposes. One cannot say its inherent or plenary power to correct the record is taken away completely because of section 5 of the Arbitration Act. This is a power that pre-exists pre-Constitution, reaffirmed by Article 215 of the Constitution. And one other judgment of your lordships, in Jyoti Bhushan's case, item 12, page 550, slightly different point. 550 of the compilation. This is in 1962 supplement 1 SCR, page 73. And the relevant para is paragraph 9, which starts at page 553. But may I go straight to page 554 to save your lordship's time and read the last portion of para 9 at page 554. After the extracted portion on the top of 554, there is a paragraph starting with counsel for the appellants. About halfway through that paragraph, after referring to the Privy Council decision, the sentence starting with the jurisdiction to deal with the claims of companies ordered to be wound up is conferred by the Indian Companies Act, and to that extent the letters patent are modified. There is, however, no difference in the character of the original civil jurisdiction which is conferred upon the High Court by letters patent and the jurisdiction conferred by special acts. When in exercise of its authority conferred by a special statute, the High Court in an application presented to it as a court of first instance declared its liability to pay a debt, the jurisdiction exercised is original and civil, and if the exercise of that jurisdiction does not depend upon any preliminary step invoking exercise of discretion of the High Court, the jurisdiction is ordinary. So even under the Arbitration Act under 34, it is the ordinary original civil jurisdiction which is plenary in its scope.
That's Hemji or Grindley.
Now, my lord, as far as other courts are concerned, I'll be very brief. My lord, I have 2 or 3 judgments and points and I'll be done. In ITI Limited and Siemens, which your lordships will find at page 717 of this very compilation, two judges of this honorable court, the citation is 2002 5 SCC 510, and at para 13, which is at running page 724 of the compilation, the court negatived the argument based on section 5, and I quote, "We also do not find much force in the argument of counsel for the appellant based on section 5 of the Act. It is to be noted that it is under this part, namely part 1 of the Act, that section 37(1) of the Act is found, which provides for an appeal to a civil court. The term court referred to in the provision is defined under section 2E of the Act. From the said definition, it is clear that the appeal is not to any designated person, but to a civil court. In such a situation, the proceedings before such court will have to be controlled by the provisions of the code, and therefore the remedy by way of revision under section 115 of the code will not amount to a judicial intervention not provided for by part 1 of the Act. To put it in other words, when the Act under section 37 provided for an appeal to the civil court and the application of the code not having been expressly barred, the revisional jurisdiction of the High Court gets attracted. If that be so, the bar under section 5 will not be attracted, because conferment of appellate power on the civil court in part 1 of the Act attracts the provisions of the code also." Now, as I pointed out, the next judgment at page 728 in MTNL, also of 2 judges, says we are bound by ITI, but we disagree with the statement of law. We find the statement erroneous, and they referred it to a larger bench. That is in 2017 2 SCC page 37. But that reference is still pending. To the best of my knowledge,
which is the paragraph 11?
Paragraph. In MTNL, para 27. I'm sorry, para 27. At running page 741, the last page of the judgment. And they do so on the footing that they say the Arbitration Act is a complete code. Now, if ITI is correct, then the CPC applies, which includes 151. So all courts, including district courts, will have that power. The necessity is for your lordships to define what that power is and to ensure that it's strict and disciplined within 34. That itself will be enough. Now, my lord, one last judgment of your lordships, which I must place before my lords, is the bench of 7 judges in the Stamp Act matter. That is item 13, page 556 of this compilation. I want to just read 4 paragraphs, 4 short paragraphs from this judgment. This is reported in 2024, 6 SCC, page 1. The first para is para 67 at page 627. At 627, para 67, your lordships hold. Arbitration is a method of alternate dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. Running page 627 of the compilation. I'm so sorry. Para 67. Arbitration is a method of alternative dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. The aim of arbitration is to provide speedy, efficient, and binding resolution of disputes that have arisen between the parties in regard to their substantive obligations. The thrust of arbitration law is succinctly encapsulated in Redfern and Hunter. It is to be expeditious where the law is slow, cheap where the law is costly, simple where the law is technical, a peacemaker instead of stirrer of strife. Relegating a successful party to a new round of arbitration, stirrer up of strife. It cannot be in consonance with the objects of this act. Then if my lord see para 81 at page 631. This is a little important because my lords have interpreted section 5 and given its correct scope and meaning. In para 80, section 5 is set out. But then if we go to 81 at page 631 of the compilation, what your lordships have held is this. One of the main objectives of the Arbitration Act is to minimize the supervisory role of courts in the arbitral process. Party autonomy and settlement of disputes by an arbitral tribunal are the hallmarks of arbitration law. Section 5 gives effect to the true intention of the parties to have their disputes resolved through arbitration in a quick, efficient, and effective manner by minimizing judicial interference in the arbitral proceedings. Parliament enacted Section 5 to minimize the supervisory role of courts in the arbitral process to the bare minimum and only to the extent so provided under Part 1. In doing so, the next sentence is very critical. In doing so, the legislature did not altogether exclude the role of courts or judicial authorities in arbitral proceedings, but limited it to circumstances where the support of judicial authorities is required for the successful implementation and enforcement of the arbitral process. Therefore, an interpretation of 34 that supports the arbitral process, supports the aims of finality and speed, is not contradictory to Section 5 at all. And then one more para.
No matter, subject to what Mr. Banerjee and Mr. Kripal may say, you may also consider this.
Yes, ma'am.
Instead of this bifurcation between high courts and civil courts.
Yes, ma'am.
See, Section 5, if it is to be construed as a bar, this court, even in the context of a constitutional bar in 329,
yes,
has said that anything in furtherance of the object
precisely
will not be impeded. If it is to frustrate, yes, we will invoke the bar. So Section 5 will not come in the way of any interpretation which furthers the object of the act. In a way, what 81 says, if you have support in the constitutional context,
I'm truly obliged. That is
subject to what they
that
say.
is precisely what the 7th Judge said in para 81.
Then the last words, unless provided in the act, will be read to mean that 34 implies this power. This is of course subject to what they say.
Lordship. 81 clearly holds this in interpreting Section 5. One more paragraph, 84, at the bottom of page 632 of the compilation. After setting out the non-obstante clause in which Section 5 starts with, para 84, what your lordships say is although a non-obstante clause must be allowed to operate with full vigor, its effect is limited to the extent intended by the legislature. In ICICI Bank and Citco Leathers, a two-judge bench of this court held that a non-obstante clause must be interpreted by confining it to the legislative policy. Thus, even if a non-obstante clause has wide amplitude, the extent of its impact has to be measured in view of the legislative intention and legislative policy. In view of this settled legal position, the issue that arises for our consideration is the scope of the non-obstante contained in Section 5. And then the judgment in Morgan Securities is also cited. And the last line of para 85 says, In other words, the scope of the non-obstante clause is limited to prohibiting the intervention of judicial authorities unless it has been expressly provided for under Part 1 of the Arbitration Act. So, judicial intervention, if in support of the aims and objects and legislative policy, is not proscribed by Section 5 at all, because that would turn it on its head. Section 5 can't be used as an instrument to destroy the objects of the Arbitration Act, which is speed and finality, and which it would be if it is used as a fetter on Section 34, power of modification in certain limited and extenuating circumstances, to prevent a miscarriage of justice, to correct a patent error of law, the correction of which alone turns the award. Take my own case. I know my laws are not going to facts, but as an example, the three applicants, one is an 82-year-old widow who's been out of her home now for almost over 20 years, and her two sons. The award, the tribunal, we succeed completely on an agreement that is entered into, specific performance, our right to get our alternative accommodation, which was promised to us under that contract, readiness and willingness, everything the tribunal upholds. But then it says in one pithy paragraph, and I'm not obviously in challenge before your lordship, that these three are fiduciaries of the company with which they enter into the contract, ignoring the fact that the mother was not even a director of that company, but of some other subsidiary or associate company. One of the sons was not a director. One son was a director, but admittedly did not participate, and under Section 88 of the Trust Act, did not avail himself of his character. But it's like, too bad. Therefore, this contract is bad unless approved by the shareholders. Just in one sentence, contrary to a lot of judgments that we cited. Now, that's patently an error of law on the face of the award. The dissenting judgment, in fact, decides again everything in our favor on this point, says no question. 88 has no application. And these are not fiduciaries. Ex facie, a non-director can't be a fiduciary unless there's some other capacity pleaded, which in this case there's not. Now, in such a case, if the 34 court feels that that 2 or 3 sentence unreasoned finding on law is patently erroneous, and the correct law is that they are not fiduciaries, and 88 does not apply, then surely it should be permitted to incorporate that into the award, and with consequential changes, that's the end of the matter. If I succeed in 34, the matter is still pending, the best result I can get is restart the whole arbitration. 82-year-old widow has to restart a whole arbitration with evidence, trial, etc. Now, I've just prepared a one-page note, if your lordships, on the facts of my case. I've already summarized them, so I don't want to read it again.
No, facts of the case, to be very frank, will not be.
Yeah, but as an example, only as an example. Now, my lord, therefore, I come to the final part of my. So just one.
Not there is an intervener button, but we don't even know whether the other side is here or not.
Wait, I'm not asking my lord to go into facts. I'm arguing it is only as an example.
Say not facts of your case in a given case.
In a given case, I appreciate that. No? In a given case, this could happen. I gave another example of limitation that is equally unfair and harsh. And to decide that an award is vitiated by patent illegality, of necessity, the 34 court would have to say and determine what the correct position of law is. So there's no extra determination being done. Therefore, that approach would end a dispute rather than perpetuate it for generations. I mean, I'll just refer to it. I won't cite it. In Deep Industries, which is also set out in page 535 of this compilation, 2020-15 SCC 706, para 17, my lords have held, constitutional powers can't be taken away by Section 5 of the Arbitration Act. Therefore, I come now to the summation. I commend to your lordships to follow, in part at least, the procedure and law in England. In England, there is an express variation power. Let us be very clear about it from the beginning. But it's couched in general terms, power to vary the award. That's all it says. But English courts and English commentators have narrowed that power. And the best enunciation of that narrowing of the power is found in Mustill and Boyd, which my lords will find at page 260. Just one sentence of this compilation. At 261, varying the award, just one sentence. The heading starts varying the award. First sentence is an order varying the award will not necessarily result as a matter of
From what?
Mustill and Boyd, second edition,
Okay.
page 261. Order varying the award will not necessarily result as a matter of course from a successful appeal. We suggest that such an order will only be appropriate where the variation, including any variation of the award on costs, follows inevitably from the court's determination of the question of law. So it must then be obvious. It doesn't require a revisitation, reappraisal, a redetermination of anything. And English courts have held, including the judgment in Fencegate at page 265 of the compilation, that even this wide power of variation is restricted to the two essential requirements. And I'll just state them for my lords. One is, it must not involve a fact-finding exercise. You must take the arbitral records as you find it. No variation, reappreciation of facts. And the second is this: the variation must flow inevitably from the court's determination of law. Yeah, I've said that. I'm not reading it, my lord. It's in my written submission that I've referred to it. Therefore, if we apply a similar principle to 34, what is the discipline of 34? The discipline of 34 is it's not an appeal. One cannot reappreciate evidence. One cannot go into merits. That is an express prohibition in 34. However, if any part of the award is vitiated by a patent illegality, that part can be severed if the conditions exist and set aside. The only interpretation would be that instead of stopping at merely cutting off the objectionable portion, if the objectionable portion can be substituted by an inevitable position of law which flows from that patent illegality, then that should be done. And then obviously whatever consequential changes are required to the award, only out of that question of law.
This may sometimes lead to a lot of issues and problems. The courts may sometimes interpret it, how it can be segregated, what cannot be segregated. Itself can become a huge issue in many cases.
My lord is right, which is why I
That may
respectfully,
itself have the effect of
my lord is right. My lord is absolutely right. In fact, I am equally concerned about opening of a complete
on
flood.
your part quite apparent to us.
My lord, I'll tell my lord, if my lords issue directions under Article 142, now my lords have already done that in the context of arbitrators' fees in the AFCON's case, which is also part of this compilation. It's not limited to fundamental rights as the learned solicitor said. If my lords limit that power which is interpreted only to a situation either of complete miscarriage of justice or where the question of law, if reversed, will inevitably lead to a different position,
You see,
that would be sufficient protection in my
that
respect.
day I gave you the example of a counterclaim
Yes.
wherein penalty has been allowed. The court may say, okay, you all know what is the range. Let's fix a reasonable amount and
Gotcha.
finish it off. Well, now, somebody may say court can do that. Court can do that. In your case, probably the facts, or the given case, the facts may be such, but where do we then draw the line? Mr. Dattar suggested curable defects.
My lord is
Not
right.
curable,
What I am commending is if my lords say that,
which cannot be cured.
may I suggest one more thing? My argument does not extend to the head of public policy because that is a far grayer area. So international commercial arbitration will be in any case ring-fed.
No, no.
It will not.
The difficulty in accepting that argument is it will apply across the board to 34.
Only to patent illegality.
So that may not be correct.
If the test that I am suggesting
That may not.
of where it inevitably flows from a
It's
determination
not,
of
we
the correct.
cannot visualize all the circumstances.
My suggestion is, my lord, if it's restricted to patent illegality, because it inevitably flows. Public policy is too grey an area to say what is the correct public policy, what is not. But if it inevitably flows, then it subserves the object of finality and speed.
Public policy.
Yes. Explanation one,
Yes.
under 34(2)(b). Public policy would go to the extent of covering anything that is in conflict with the most basic notions of morality or justice. That is throwing the
That is
case
right. Therefore, I'm not commending that. My lord is absolutely correct. Therefore, I made pains to say, I'm not saying the approach I'm commending will cover public policy issues. Only questions of patent illegality, which my lords will of course find in subsection 2A, a separate subsection to 34.
So interest can't be touched because it may arise in an international commercial arbitration award.
Because it would be patent illegality. It might not. But all such questions arising in domestic arbitrations where there's a patent illegality, not a public policy issue, is what I suggest the court gives consideration to. Given the extent of the problem and the hardship, we appeal to your lordships to then, this is the solution we have to offer, which I think if your lordship passes guidelines under Article 142, it can be contained. I'm deeply grateful, my lord, for the time that has been possible.
One line.
No, may I?
It can be subject matter of severance. Section cannot.
I'm not asking for that.
The last part was, it don't apply it to the 2A, apply it to others. So section.
No, my learned friend has misunderstood. I said my test that it must inevitably flow cannot be applied to public policy because it won't inevitably flow. It can only be applied to a question of law.
No, if we accept that argument, it will defeat the earlier arguments. It's contrary to that, because the earlier argument was relying upon different concepts, whether it was a constitutional power, inherent power,
Right?
or subsumed power.
My lord is right. Therefore, I
So if we
started by
accept that argument,
No, I said,
then this is contrary to that.
No, I said-
That it will be there, but it will not apply.
may I clarify, my lord? I don't want to.
Next, you can say public policy, it will not apply because
Or to
that's a
prevent
bypass.
abuse, miscarriage of justice. I've also added that. I've not said a miscarriage of justice case can't be modified. That also.
This
That
can
and-
be with yourself.
Yes, may I be permitted to put in a short supplemental submission because some of the judgments I put in my original submissions are not there, the ones I've cited. May I be just within a day or two, by tomorrow I'll file. Only what I've argued, nothing more. Very deeply clear.
in 2 pages.
Not more than,
It's not such a.
not more than 2 pages. I bow to that. Very grateful.
May I appear? I appear in item number 501.2 for the petitioner. And in my submissions, I had cited certain judgments, some of which have been taken care of by the previous council, my lord. Well, I'll be to the point. And your lordship may kindly appreciate my submissions in 3 broad heads, my lord. First is the legislative intent as regards modification. Second is the contours of the power for
What is
modification.
your name, council?
I'm the main council, my lord.
What is your name?
Vaibhav Dang, my lord.
Sorry?
Vaibhav Dang.
Vaibhav?
Dang. And third point, which I will be making, my lords, is with regard to the requirement for the looking into in the judgment of the Hakim, my lords. My lords may kindly have the Bail Act itself. And my first submission is that the legislature is not averse to the modification, rather the intent of the legislature, as we can gather from the act itself, is in favor of the modification. And for that, your lordship may kindly have section 8B of the act, my lords. Your lordship have it?
Yeah.
Power of the court seized of matters under section 34 or 37 of the act to refer the dispute to mediation or conciliation. 1. If during the pendency of a petition under section 34 or an appeal under section 37 of the act, it appears to the court that there exists element of a settlement which may be acceptable to the parties, the court may, with the consent of the parties, refer the parties for resolution of their disputes to mediation or
But
conciliation.
this is applicable to the Union Territory of Jammu Kashmir.
Pardon me, yours?
This is applicable to Union Territory of Jammu Kashmir.
But that is where the indication for the intent is. If it is applicable for the UT of the JNK as well as the Ladakh, my lords, by the order in 2020 which the parliament had passed, then it shows that the parliament is not averse to the modification per se.
This was a state amendment.
State amendment, my lord, only with regard, but done by the parliament. It has been done by the government itself, my lords, union government. It's now a UT.
It has been done only insofar as Union Territory of.
But only with
That
regard.
apart, let's be very clear. That apart, let's be very clear. Even if there is an award,
My lords.
the parties enter into a settlement, the parties can by agreement get over the award.
But kindly have the state
Because
2H.
Because that's even with regard to a court degree that applies.
No, kindly have 8B2H for a moment.
Aspect. The parliament was exercising powers of the legislature in view of the president's rule. So it is a state amendment.
It was still done by the parliament in my respectful submission, my lord.
It is, yes, done by parliament
Sure, my lord.
as
For the state.
legislature of the state.
And kindly have, my lord, this subclause H, my lord. Such a mediated settlement shall have the status of a modified arbitral award.
That's even true even in the conciliation provisions of this act, which we have never resorted to, which we have never sought the-
Submission over here is there is an award passed by the arbitrator when the proceedings are pending before the court under section 34 or under section 37, and the court with the consent of the parties refers the parties to
Okay,
mediation.
we have understood this argument.
Then the award itself can be modified, and that modified award will be the one which will be enforced under law. So the parliament is not per se averse to the modification. That's my one submission, my lord. But so far as the contours of modification, in addition to what has already been argued, my lord, my respectful submission is, my lord, kindly have my written submissions. I have given 3 instances in which the modification.
Where is your submission?
I have given the hard copies.
Yes.
Now kindly have page 3 of my submissions, my lord. Para 7(4), my lord, Roman. This I was referring in context of the Hakim also, but still kindly have these 3 situations which I have envisaged. One is the mutual consent of the parties. As I was referring to 8B also, if the parties during the pendency of the proceedings. My lord, has it? My lord, has my lord. My lord, the first suggestion which I have is, my lord, in the circumstances, my lord, the first is the mutual consent of the parties. My lord, if during the pendency of the proceeding before the court, both sides request the court, my lord, either to go for mediation or otherwise, that they have decided to end their dispute in a manner which is otherwise done by way of the award, my lord, what the award says, then there is no embargo against that, my lord. Court can put its stand for approval over there. And that would also amount to a modification of the award itself. Because the arbitrator, what the award he has passed, it will not be then that award which will be enforceable, it will be then the modified award. The second situation, my lord, is to correct the error or interpret a specific point or part of the award as per section 33, 1A and B of the Act. Now, what the arbitrator can do under section 33, my lord, to a limited extent, my lord, that the court can also do it when the proceedings are pending, my lord. But what so happened in my case, my lord, I'll just briefly refer, and in a given case, it can be taken as an example, that in this case, what happened was that the original contract value was reduced during the pendency of the contract, my lord. The arbitrator awarded the sum on the original contract value toward the overhead charges. Now, when the matter traveled to 34 court, my lord, the court said no. There is a fundamental breach on the part of the department. You are entitled to the overheads. There is no dispute to that, but not on the original contract value, but on the reduced value of the contract. But the court did not give me that because the court found that the award cannot be modified to that extent. Now I went in 37. The 37 court also upheld the same position, that you are right in saying there is a fundamental breach. You are right in claiming the overhead. Your entitlement for the overhead is also justified. But we can't give you that because that would amount to modification. So what was required to be done was, instead of looking at figure A, the court was only required to substitute the figure A by figure B. But the court did not do, because the court said that would amount to a modification of the award. Now for that very reason, a fresh arbitration will have to be undertaken. So my submission is, if only a correction of the amount, which the arbitrator also could have done under 33, can substitute and replace the figure and the ultimate outcome can be maintained, because there is no dispute by the department with regard to the amount as such. If that can be maintained, there was nothing preventing the court from doing that. The court would have very well done that. Now the third submission is with regard to is the circumstance where the court, to ensure parity, especially while dealing with the cases involving the payment of compensation under the acts such as the National Highways Act. Now here is an example over here for this, my lord. Kindly have the judgment which I have filed along with this very compilation. The third judgment, lord, of Abdul Ismail Said, Division Bench of the Madras High Court, my lords. Well, the first scenario under Order 23, my lord.
It's analogous.
Principles, my lord. No, my lord. My submission is, my lord, if we look at in the context of section 8B, then it is supported over there also. Basically, when the court is even referring the parties to mediation, it is acting with the consent of the parties. When the consent is there in the first scenario which I propose, consent is there, modification can be done whether it is done through mediation, conciliation, or the parties otherwise approach the court with a settlement, which the court will independently look into. 8B very clearly says, once the mediation settlement is sent back to the court will judicially look into it and pass appropriate orders. That is what the language of 8B is specifically. So when the court is passing an order, and then order is then a modified award enforceable under section 33, it encompasses all the situations where the award can be modified. Now, in this very judgment, my lords, Abdul Ismail Said, lordship may kindly have para 59.
Page number?
Page number, my lord, 108. Para 59 starts at 107, bottom. I'll be reading from 108, my lords. 7th line from the top, my lords. Now, this was a live case, my lord, where the Honorable Court Division Bench of the Madras High Court, my lord, looked into Western Gecko judgment also, 3 judges case. And it upheld the modification, my lord. Mary, my lords, page 108, 7th line.
Lord, I just wanted to point out, Western Gecko is pre-2015. The ratio in Western Gecko has been legislatively overruled as recognized in SANIOM. So I just wanted to point that out on Western Gecko.
Yes, please.
7th line from the top at page 108, my lord. Even in cases, my lords have it?
Yes.
Even in cases where award of the district collector is set aside. Now, my lord, what happens is under the National Highways Act, section 3, my lord, the arbitrator is given under the statute, which is the district collector, my lord. My lord, district collector, then either party can go for the reference, my lord. He passes an award and then the decision comes, my lord. Now, the subject matter of this case was that only. The Honorable Division Bench said, even in cases where the award of the district collector is set aside and remitted, there is no guarantee for getting compensation with an application of judicial mind. As a result, the landowner may spend enormous time in courts with no hope. unless the provisions of Arbitration and Conciliation Act, which has now been incorporated into the NH Act, are interpreted to remedy the situation following the judgment of Honorable Supreme Court in ONGC versus Western Gecko, which we consider to be fair, at least while interpreting Section 34 as applicable to the NH Act. Otherwise, there will be grave injustice to a section of people whose lands were acquired under the NH Act. When Honorable Supreme Court in Tarsem Singh's case Supra has declared that provisions of Land Acquisition Act relating to solatium interest contained in Section 23(1)(a) and interest in terms of proviso Section 28 will apply to acquisition made under the NH Act, and that Section 3J is violative of Article 14 of the Constitution, the court is of the view that in the same spirit, the provisions of the Arbitration and Conciliation Act, which have now been incorporated into the NH Act, have to be interpreted for the purpose of determining the compensation, bearing it in mind to save the Act otherwise being unconstitutional and violative of Article 14 of the Constitution. Para 60. When the Honorable Supreme Court in several judgments, including the judgment in M. Hakim's case, have uniformly observed in every case that they do not intend to interfere with the judgment of the High Court, even where the award of the collector had been modified by court for doing complete justice, the inference that can be drawn is that power to modify the award is necessary to render justice, for which we constitutional courts are meant for. Learned amicus curiae in this case has relied upon a few judgments of Honorable Supreme Court, where courts have interfered with the award on merits by modifying the award, even though there is no discussion or issue being raised therein, whether the courts have power to modify the award. Maybe all those judgments relied upon by the learned amicus curiae need not be cited as a precedent, as distinguished in M. Hakim's case Supra, but the power of court to modify the award should be made available when it is applicable to challenge the award under the NH Act, in larger interest of public to render justice and to ensure the constitutional guarantee to which every citizen is entitled to. Para 61 minutes. The learned counsel appearing for the third respondent produced before the court judgment of learned single judge of this court in the case of Project Director NHAI versus R. Jayakumar, so and so. It is a case where the NHAI filed the appeals as against the order of the Principal District Judge Salem in so and so under Section 34 of the Arbitration and Conciliation Act. The learned Principal District Judge Salem, though confirmed the award passed by the arbitrator, District Collector, on the quantum of compensation, directed the NHAI to pay 12% interest on the market value from the date of modification of the to the date of the award, and also directed to pay 30% of the award amount towards solatium. It is to be noted that the order of the Principal District Judge is in accordance with the judgment of the Honorable Supreme Court in Tarsem Singh's case. Messrs. NHAI challenged the order of the Principal District Court mainly on the ground that the court has no power to modify the award in a petition under Section 34 of the Act, and that therefore awarding interest which is in the nature of modification of the award is impermissible. The learned single judge relied upon the judgment of the Honorable Supreme Court in M. Hakim's case, placing reliance on para 39 to 58 of the judgment in M. Hakim case. The learned single judge held that the district judge ought not to have modified the arbitral award passed by the district collector and set aside the impugned order passed by the principal district judge in so and so, even though interest in some terms of Section 23(1)(a) and solatium at 30% are now payable as per the judgment of the Honorable Supreme Court. In Tarsem Singh's case, the learned single judge set aside the order of the Principal District Court. The judgment of the learned single judge shows that the landowner is denied the relief which he is entitled to as per the judgment of the Honorable Supreme Court. Since the interpretation of statute should be purposive and taking into account the possible mischief or prejudice that is likely to be caused to the landowners, this court is of the view that Section 34, when it is applied to the NH Act, the power of court to modify the award should be read into in public interest. Having regard to the long discussion of several judgments examined by this court is inclined to follow the judgment of three-member bench of this Honorable Supreme Court in ONGC versus Western Gecko, upholding the power of the court to modify the award, particularly when the unamended provision under Section 34 of the Arbitration and Conciliation Act is incorporated into the NH Act subject to the provisions of the NH Act, my lord. So the courts have read into this power by following the three-judge bench decision. Now, my lord, the next point which I'll making, my lord, is with regard to the Article 142 power, my lord. I should know, my lord, that power is exercised to do complete justice.
So that will not go into.
No, my only humble submission is that,
Go into that.
when that power is exercised to do justice, what it means is, as per decision of this Honorable Court, my lord, Constitution Bench in Supreme Court Bar Association, my lord, the court, while exercising that power, will not do anything which is against the intent of the statute to do something indirectly which is directly prohibited. So my summation is, when that power is exercised and the court is doing something which is not barred under the statute, obviously the same can be done by the civil courts also by exercising the power under section 151 of the CPC, if the provisions of CPC are read into the statute, my lord. That's my summation on that point, my lord. Thirdly, my lord, is on the aspect of the decision in the case of, my lord, M. Hakim, my lord. And my submissions over there, my lord, is with regard to that it requires reconsideration, because that was passed in the context of the NH Act only, my lord. It was not passed in a matter which was not dealing with any other statute, in the sense that broader Arbitration and Conciliation Act. The court was seized of the matter in the context of the NH Act. Under the NH Act, section 3, my lord, there is a district collector who is acting as the arbitrator, my lord. Now, I have filed the memorandum also on record issued by the government. The district collector is paid a very nominal fee, my lord. He is paid, as per revised schedule, my lord, 500 rupees for 1 day hearing, my lord, subject to maximum of 10,000 rupees, my lord. That is his entire fees for the arbitration, whichever party goes to invoke the arbitration, my lord. As against that, my lord, if the private party goes in and invokes the arbitration, 4th schedule at least applies, my lord, where the burden of the cost in the event of a re-arbitration will be much more when the party having spent considerable amount of time as well as resources in the previous round of the arbitration and in the subsequent litigation up to whichever court, my lord, the matter may have traveled to. Now, if the parties are then sent back to reinitiate the arbitration, the aspect of the cost element, my lord, and the financial burden that will be caused on the party as a result, therefore, my lord, has not been considered in the case of the N. Hakim, my lords. That's one submission, my lord. And the office memorandum is already there on record, which shows what amount is being payable. And this office memorandum, my lord, came up before the Honorable Division Bench of the Punjab and Haryana High Court, of which Justice Masih was part, my lord. I filed the judgment also on record, my lord, as a consideration where the arbitrator went ahead and charged a fees, my lord, which was over and above the office memorandum. The Honorable Division Bench in that case said, my lord, it is completely illegal. You have to go only by the nominal fee. So when in that case, my lord, under the NH Act, there is a fixed amount of fee, and still the court is saying that remanding the parties back for re-arbitration, my lord, is not workable. For
Why do you say that? The 3G7, which is expected in Hakim,
like, my lords,
expands the power of an arbitrator under the NHA Act,
lords.
gives the arbitrator power to determine market value under 3A.
Well, the court, my lord, in this case, my lord, ultimately upheld the fact that the submission is, my lord, with regard to whether it was a consensual arbitration or a non-consensual arbitration. That was one of the aspects the court was seized with. The court said, irrespective of that position, the Act provides with regard to a forum to be there for the adjudication. You have to go to that forum. Even in case of a modification, the court cannot do the modification.
No, just in 3G7 in Hakim Para 12.
Para 12, my lords, just.
There seems to be an expansion of the power of the arbitrator
3G, my lords, Para 12.
in Hakim by page 13.
Section 3G, my lords?
3G.
3G.
Subsection, see, first it goes to competent authority, then it goes to central government, then it goes to arbitration. Now, 6 says Act will apply, 7, just read 7.
The competent authority or the arbitrator.
Or the arbitrator. Now read.
While determining the amount under subsection 1 or subsection 5, as the case may be, shall take into consideration the market value of the land on the date of publication of the notification.
That's a redetermination done like the reference code.
No, my lord, my submission over here is, my lord, the arbitrator,
understanding.
the competent authority or the arbitrator. My lord, when the matter goes to them, my lord, do not decide on the basis of the market value of the land and still passes an award. What is the recourse available against that? The only recourse as per the scheme of the Act is section 34.
Post this stage, you are saying.
Post this stage, my lord. And we are also concerned with the post stage of the award. When the award is already there, be it passed by the competent authority under the NH Act or the arbitrator under the NH Act or under any other contractual matter relating to a constructor or a builder. When a stage of award is already passed, and the matter has been decided one way or the other. Now, who is to then remedy it? So the Honorable Court, my lord, in this case, my lord, holds that you have to go back to the arbitrator because he is the person. But the cost element which is involved in all other private arbitration, including the institutional and the international commercial arbitration, re-invocation of the arbitration, my lord, that aspect has not been considered over here. Under the statutory arbitration, where the official is a government official bound by the official memorandums of the government, where the amount is fixed, not more than 10,000, 20,000 rupees in certain cases. The re-invocation of the arbitration, at least on the cost element, can be considered as not onerous to the parties, my lord. Here in the cases of the private arbitrations, when we have to go back, now arbitrators normally in all the matters, my lord, they don't normally give the actual cost incurred by the parties. What they give is the notional cost, even with regard to the fees also, my lord. When the parties go back for the arbitration, they have to incur the entire fees and the expenses with regard to the arbitrator, with regard to the lawyer's fee, and then wait for the final adjudication of that award also through the process of the court. That entire process, my lord, is a cost.
It's already argued by Mr. Kambata and Mr. Datta.
No, that's what I'm not insisting on that point. I'm just simply referring to it in this context, my lord, that Hakim did not consider the aspect with regard to the cost element on the process of re-arbitration, my lord. That's what one point is, my lord. And my lord, one judgment, my lord, which I cited in the compilation, my lord, the second compilation which I filed, my lord. It's the Alpine Housing Development, the second volume, my lord. Just briefly, my lord, with regard to the applicability of the provisions of the code, my lord. Though Mr. Kambata has argued on that, my lord, with regard to the inherent powers. And it was also indicated before this honorable court that the judgment in the ITI Siemens has been doubted by the division bench in the subsequent case. My lordship may kindly have this judgment of Alpine Housing Development. Division bench of the Karnataka High Court, my lord. Just a few passages. Page 81, my lords. The last 8 lines. Now, it was in the context of the Consumer Protection Act and the applicability of the CPC over there. The Honorable Division Bench says a perusal of the lordship have it or not? Lordship have? A perusal of the entire Consumer Protection Act 1986 would disclose that the provisions of the Code of Civil Procedure 1908 have not been excluded. Generally speaking, the Code of Civil Procedure only codifies in one code what may generally be viewed as the general principles of law concerning the procedure which we are concerned to be handmaid to justice. If the Commission had the power to set up ex parte any person before it, while it is still seized of the dispute, it would also have the inherent power to also recall or reverse such an order, or also restore the complaint on good cause being shown if it is dismissed for default. The issue over here was dismissal in default. But my summation is, if the provisions of the CPC are generally being adopted by the court while dealing with the cases under section 34, surely 151 CPC is also available to the court, because the court, when it sees of the petition under section 34 or 37, issues the notices for which the CPC is followed, dismisses the petition in default for which the CPC is also followed.
That's all?
That's all, my lord.
Okay, now how many? You are Mr. Rai, you are there?
Yes.
How much time will you take, Mr. Rai?
But I'll take 15 minutes. I've in fact prepared a new 3-page.
Okay, others may then confide. Okay.
Because on the specific aspect of 34.4, which fell from Justice Vishwanathan, I can just take 10 minutes whenever my last part.
34.
First, it just have a solution. I'm sorry.
Okay, just sit among yourselves and then decide who's going to begin. Give a slip of papers to everybody. We'll call out the names by slip of papers.
Obliged.
The forecaster will call out your names, call out names, and then we start. I don't want everybody to be coming up and sitting up at the same time.